Hello there. Welcome. This is the Employment Law Show. It's good to have you along for the week. Thank you so much for sticking around. If you got the complete half hour, we'd love to entertain you and inform you and educate you over that 30-minute time period. It's John Scholes here. Right beside me, Lior Samfiru, employment lawyer at employmentlawyer.ca. Always reach out to Lior with any questions beyond the show. 1-855-821-5900. Help at employmentlawyer.ca. We'll give you other content throughout the half hour. I don't want to throw it all at you at once, but we do have a main topic every week, by the way, in the second segment of the show. Guide to accommodation in the workplace. Hugely important, so stick around for that. We'll get to some emails, some phone calls, and a ton of other stuff, Lior. But the week that was, a case of the day to warm us up again. This week, what do you got going on?
Hey, John, really exciting time to be here to talk about employment law rights. You know, the past few months with everything going on south of the border have raised a lot of questions in the minds of employees and employers, and legal rights have become more important than ever. So we're here to talk to you about what to do if your job gets impacted, if you lose your job, if your job gets outsourced. AI, man, AI a big issue. What happens if you lose your job to AI? What are your rights? What do you have to get paid? And of course, what to do if you're just not being treated properly by the boss, by the company, if your HR is not helpful, if you're on a disability leave and your employer is giving you a hard time. So many things to cover and so many things to discuss. We try to get to as many topics as possible on this show, but 30 minutes is going to go by fast. Beyond the 30 minutes, you can reach me in the office. We can have a private chat, phone or email. So we'll give you that contact information throughout the show. Please use it. Make sure you do that. But I always like to start off with the case that came across my desk very recently. This one, John, really I felt bad for the individual. So this person was planning a very big trip and he wanted 3 weeks off work. He asked his employer months and months in advance for that time off. Initially, the employer was kind of reluctant. He said, we usually don't want people gone for more than 2 weeks. Eventually, the employer agreed and said, yeah, we'll allow you to take the 3 weeks off so you can do your trip. Fine, no problem. So fast forward, trip comes, employee leaves on the trip. About a week into this trip, he gets a text message from his employer saying, things are kind of falling to pieces back at work. We need you to come back as soon as possible. So finish the second week, but then you got to come back to work and not take that third week off. Employee responds, says, well, what are you talking about? I'm off. I'm on this trip. I'm away. I've planned it. You've known about it for months. You've approved it. I'm not going to be back to work. Well, wouldn't you know it, employee does come back after 3 weeks, except when he shows up to work, the employer says, no, you resigned. You've abandoned your job. We told you to come back to work a couple of weeks ago. You didn't do that. You've abandoned your job. You no longer work here. Goodbye, pack up your things, and you're gone. Wow. Obviously, this person was very upset, emotional about it. It's a job that he had for years, loved the job, and he thought he did everything right, which, frankly, he did. Luckily, he called me and he wanted to understand his rights. So guess what, John? It's not job abandonment. He got this time approved. He didn't just decide to take off and told his employer, too bad, deal with it. He was away on an approved trip, and his employer can't change that part way. Now, if his employer told him months before, hey, we've changed our mind, you're not going to be able to take 3 weeks off later this year, you're going to have to take only 2, well, that'd be different. But while he's already away on vacation, his employer can't change that. So this is not resignation. It's not a job abandonment. It's a termination. His employer terminated his employment. Now they have to pay the cost. The cost, of course, is severance. This person had been there for about 15 years or so. He's going to be looking at 18 to 20 months of severance. That's how much this is going to cost this employer. So the message here is very clear. Your employer can't just decide that you've resigned. They can't just decide that you've abandoned your job. If you're doing what you're supposed to, they can't just change the game or move the goalposts. If they do that, that becomes a termination. So for this guy, he's going to get his severance. His employer did this wrong. Maybe they should not have approved the vacation, but they did. Can't change that. Now they're going to have to pay that severance.
Is it always a wise idea, Lior, in this case? I mean, he's going to get his severance. It worked out on his side, as it appropriately should. But, at first there was some static about going from 2 weeks to 3 weeks. Then they finally said, okay, you know what, you can have the 3 weeks. In any case, you should always get written approval for that so they can't go back on it and create less hassle for you when you come back, threatening you with job abandonment, right?
Yeah, and here's the interesting thing is they're not denying that they approved the 3 weeks. They're acknowledging it. They're just saying, well, we changed our minds, so you should have come back to work. except that they change their minds too late. But John, to your point, yes, it's always a good idea to have that approval in writing. And frankly, you don't need anything formal from the company. You don't need a letter saying we've approved your vacation for 3 weeks. You sending an email and saying, hey, I confirm today when you approve my 3-week vacation from this date to this date. That's good enough. You send that email or text message, it's good enough. But yes, to avoid conflict or he said, she said down the road, to have something in writing, never a bad idea.
Can your employers schedule your vacation? I mean, in this case, obviously, this person had 2 weeks, went for the 3, got it approved, fine. But, you know, from the outset, can an employer say, no, Lior, you're taking off all February this year. Enjoy that, right?
And this would cause a lot of employees to be unbelievably unhappy, which is why employers generally don't do that. But yes, they could. An employer does have the legal right to decide when an employee takes vacation. They don't have to take the or to allow the employees to take the vacation when the employee wants it. They can say, hey, employee, you're taking vacation this time this year, this other employee is taking it this other time. An employer can do that. Again, very, very rare, because that would be very problematic. Employees are going to be unhappy. They may, resign and go work somewhere else. But legally, can they do that? Yes, I would certainly advise against it.
Good stuff to know, Lior. As always, this part of the show, we'd like to get to some viewer phone calls, which we're going to embark on right now. Phone call number 1. We got 2 this segment. The first one's coming up right now. Listen up.
Basically a part-time worker. I'm 77 years old. I recently asked for a raise after 5 years, and they said I would have to renegotiate a contract, which I haven't done in ages. If I ask for the raise and if they decide to let me go, do they owe me any severance?
What kind of a job? What do you do?
I'm a caretaker.
Okay, and how long have you been doing this for?
23 years.
Oh, yeah.
That's a long time. So let's break this down a bit. First of all, in terms of the pay raise, an employer generally is not required to provide a pay raise. Of course, we're talking about a non-union situation. It may be different in a union situation. But in a non-union situation, an employer is not required to provide a pay raise, whether it's a cost of living increase or any other increase. Of course, you have to make at least minimum wage. Beyond that, an employer does not have to raise pay. So you can ask for it. If they say no, it may be unfair and it may make you unhappy, but legally that's okay. What the issue here is, his concern is because he asked for a raise, they may turn around and just let him go. Well, they are allowed to let him go. Keep in mind, an employer can generally let you go for any reason as long as proper severance is paid. So yeah, they would owe him severance, but with severance, they can let him go even though he's done nothing wrong. So the last thing that we need to figure out, well, severance we know he gets, but how much severance? So we're going to go to the severance calculator tool right now and see how much he's owed. You'll find that at pocketemploymentlawyer.ca. So let's do that and see what that tells us. So we know he's a caretaker, been there for 23 years at the age of 77. Good for him. He's owed as much as 24 months of pay. You see that on the screen. 24 months is what he'd be owed here. So if the company is inclined to pay him 2 years of pay, they can let him go. Anything less than that, John, would be a wrongful dismissal.
Yeah, he's got 2 of the 3 big numbers there. He's 77 and he's got a lot of years service. Not a high-end position, but he's got the other 2, which make it 20 to 24 months, which is a great severance offer, right?
It is. And, for someone at 77 that may not have intended to work for much longer, to say, I'm going to get paid for 2 years even though I'm not going to be working, that could be a good thing for him. But that's what the severance is. And by the way, anyone at home, all our viewers, anyone, can find out how much severance they're owed, whether they actually lost their job or they're curious, they want to understand their rights. Do the same thing. Go to pocketemploymentlawyer.ca, click on the severance calculator, completely free and completely anonymous.
All right, there's phone call number 1. Phone call number 2 is coming up right now. Here we go.
I'm in sales. In my position, there's a base salary and then there's a commission structure. Over the month, typically we'd have a target to hit, whatever amount of money to sell, and then you get paid out a percentage on whatever target you hit. They changed this commission structure, but there was no real notification to the salespeople. There's no targets that are given out. I feel like, well, how do they just come up with a number to pay me?
Yeah. We'll kind of figure out how much we're going to pay you. We'll play it along as we go. Nonsense. Of course, an employer can't do that. So here's what happened. He had a defined commission structure. He knew that he gets this amount after these many sales. That's fine. His employer then changes that. It's no longer going to be the case. We're going to pay you differently. Well, that in most cases is not allowed. In most cases, that's a constructive dismissal. Your employer cannot just make significant changes to the terms of your employment, and that includes changing the way you get paid, reducing your commissions, changing your commission structures can always be a constructive dismissal. So what does he do here? If right now he doesn't know how much he's going to get paid because his employer is being vague, tell your employer, I'm very concerned about this, that this is going to affect my pay, but I'm going to see what happens over the next few months. So he continues working. If he sees that ultimately his pay is not being affected, then I guess that's okay. On the other hand, if he sees, wait a second, this new structure means I'm getting paid less, well, that's a constructive dismissal. He can still pursue that at that time. But yeah, be very careful if your employer changes your commission structure. That could easily be constructive dismissal.
And like I always ask you, a follow-up to that sales question of being let go. How do you calculate severance for someone in a commission salary base where it can be this week to week or month to month, right?
Yeah, some years you're doing amazing, other years not so good, and month to month it can change. So it's easy. For your severance, we look at an average. Depending on how long you've been there, we'll look at 1, 2, or 3 year average. And that average, that figure is the one we're going to use to calculate your severance. So if your 3-year average is $75,000, well, $75,000 is the figure we're going to use to calculate whatever severance you're owed. So the company may not like that. They may say, well, we'll look at the worst year. No, can't do that. It is an average, and that's the proper way to calculate.
All right, guide to accommodation in the workplace. That is our main topic on the other side of the break, which we'll get into now. Oh, and our third phone call as well, so stick around for that as we continue more of the Employment Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And we are back. Employment Law Show. John Scholes here. Lior Samfiru right beside me. Reach out to Lior, employment lawyer at employmentlawyer.ca. Use the website and call the number too, 1-855-821-5900. Back it up with an email. That is simply help@employmentlawyer.ca. Before we get into our main topic for the week, Lior, we'll get to that third phone call right now. Here we go.
Just gotten a new job. It was my second day into this new job. And when I got hired, I specifically told him what I was interested in doing and what I wasn't interested in doing. And we came to an agreement. Second day on the job, he changed the agreement. And when I said something about it, the supervisor got in my face. He told me and I would do what he said. I ended up arguing with him and he ended up firing me for insubordination.
Second day. Second
day. Well, let's talk about this from a legal standpoint. And ultimately, this comes down to whether this employee was on probation. That's really all it comes down to. So just because he started a new job and he's on his second day, whatever it is, does not mean he's on probation. Probation is not automatic. So he's only on probation if he signed an employment agreement that says you're going to be on probation for 3 months, and during those 3 months, we can let you go without any compensation. If he signed that, then he may not be owed anything. As unfair and unreasonable this whole situation was, he may not. Still worth looking into that agreement, but that could be the case. On the other hand, if he did not sign an employment agreement, or his employment agreement does not have a probationary term, it's quite possible that even after a few days he's owed severance. Yes, you heard me right. Even in this very, very short duration of employment, if he's let go, he may be owed severance. And that severance could be several weeks, potentially even several months, depending on a number of factors. So yeah, just because you started a job, I want you to remember, you're not on probation automatically. Look at that employment agreement. You're only on probation if that agreement says that you are. So don't assume anything. And beyond that, just because you work for a short period of time doesn't mean you can be let go with no compensation. Short service employees get disproportionately more severance than longer service employees. So if you're let go, you work for a week, a month, a year, or any other amount, let's talk about your entitlements.
All right, let's get into Lior, Guide to Accommodation in the Workplace. Here's our main topic for the show. Number one, do all employees have a right to workplace accommodation? What do you think?
So yes, all employees have a right to accommodation, but not in every situation. Give you an example. If I'm a big football fan and I want to be watching footballs on Sunday, not working on Sunday, well, my employer doesn't have to accommodate my preference in sports. That's not a legally protected ground in Canada. On the other hand, if I can't work on Sunday for religious reasons, well, that's something an employer has to accommodate. We have protections. We can't be mistreated or discriminated against based on religious reasons. So if you're seeking accommodation based on a ground that touches on a human right, you have a right to be accommodation, religious accommodation, family accommodation, and of course the big one, medical or disability accommodation. You have a right to be accommodated, modified hours, modified duties, if you have a disability and your doctor says that. So yes, every employee has a right to be accommodated if it touches on a human right, and if an employer doesn't provide that accommodation, that could be a human rights violation.
Okay, so Lior, as far as the medical accommodation is concerned, what kind of documentation you need to back that up to make it smooth?
So it's actually quite straightforward. You need a doctor's note. Really all you need, a doctor's note to say, this person needs the following accommodation, or this person has the following restrictions. They can't lift more than 20 pounds, they can't work more than 2 days a week, or they have to work remotely for medical reasons. So that accommodation is triggered by a doctor's note when it comes to medical accommodation. So you get that doctor's note, that employer has to do whatever they can to abide by that, to provide those accommodations. So they may have to allow you to work from home or reduce your hours or maybe change your job or provide help and support so you can do that. It all starts, John, with that doctor's note.
Well, you did mention, maybe lifting no more than 20 pounds or working from home remotely or other accommodations. What other kind of accommodations can you ask for? Is it a wide berth or no?
So really anything that's supported by a doctor, you can ask for. It may mean changing your job. It may mean I used to work evenings, but now for medical reasons I can't do that and I have to work days. And those are just medical accommodation. There's other accommodation you could be entitled to. For example, we call this family status accommodation. If you're a primary caregiver for your child and you have to be able to pick them up, let's say from daycare at a certain time because there's no one else, your employer must have to accommodate or may have to accommodate by changing your hours to allow that to happen. Again, religious accommodation, as long as it's supported by a note maybe from a religious leader in the community, that accommodation may have to happen by your employer. So really there's no limit to the accommodation. As long as it's possible, your employer must do it.
What do you do? What's your next steps, Lior, if there's a flat-out refusal to accommodate you from your employer?
Unfortunately, even the law is pretty clear. It does happen quite often that employers refuse. They say, well, this is too much, or we don't want you, or that's your problem. Well, if your employer doesn't accommodate, number one, you want to make sure you've corresponded with them in writing so you have that proof. But if they won't accommodate, let me talk to them. Once they hear from me, usually that changes. Oh, yeah, of course we're going to accommodate. It was all a big misunderstanding, we'll accommodate. If they still won't, we have recourse through the courts or the human rights tribunals. You have rights, but I'm always happy to push your employer to do the right thing.
Finally, can you be fired for simply requesting accommodation?
Absolutely not. You cannot be let go because you're seeking a legitimate, legally permissible accommodation. Religious, family status accommodation, disability, medical accommodation. You cannot be let go. Even if the employer is legitimately not able to provide that accommodation at that time, they can't let you go because of that. Maybe that means that we'll try something else, or you can be off work until things change, but you cannot be let go because you're seeking accommodation. That could be illegal and a violation of several statutes, so employers never do that. And if you're an employee and you're punished or let go because you're seeking accommodation, yeah, we need to talk right away.
All right, we'll slide into another quick break here, Lior. Upon our return, we'll get to your email questions from our viewers, some other questions, and the employment rights rapid fire to wrap up the show, as always. That's on the other side, so stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All righty, welcome back, Employment Law Show. Let's get to it, Lior. Facebook, by the way, LinkedIn, YouTube, the live stream with Lior and his team. You want to catch up on it, go in live, ask some questions. You always can. At ST Lawyers is the address to find that, at ST Lawyers. And for this week, Lior, here we go from the live stream. I was recruited by a very large company from a job I'd had for almost a decade. Now, just 10 months in, they let me go, saying I wasn't a good fit. I'm almost 50, and this is a specialized advisory position. How much severance am I owed?
So, John, this is actually fairly common. You're not necessarily looking to leave your employment. Someone knocks on your door. Maybe they reach out to you through LinkedIn or a headhunter. They eventually convince you to leave the job. They tell you how much better this new job is going to be, and you take the plunge and you start the new job, and things don't work out and they let you go. Well, in that situation, in most of those cases, that company that just let you go may have to pay you enhanced severance that recognizes the time you had with the previous company. Even though you didn't work for the new company for a long time, they may have to recognize time with the previous company because they recruited you from there. They induced you to leave secure employment. So that enhanced severance happens whenever you're recruited, only to then just be let go within the first couple of years or so. So now that we know that, even though this person has worked there for 10 months, he has enhanced entitlements. Let's use our severance calculator tool once again and find out how much you're owed. Of course, that severance calculator, you'll find that at pocketemploymentlawyer.ca. So let's see what it says. So we know that this person really is a 10-year employee because he was recruited from that job that he worked for 10 years. 49 years of age in a professional role. Again, even though you only worked for 10 months with the new company, he's owed 12 to 14 months of severance. 12 to 14 months. Again, he only worked there for 10 months. That's what happens when you're induced to leave a secure job. And that's yet another reason why you must check out that severance calculator. If you lose your job, if you're thinking it's coming up, pocketemploymentlawyer.ca.
All right, yet another resource for you to reach out, ask questions. They may appear on this show at some time. Terminationquestions.com. It's free, it's anonymous, easy to use. From it, Lior, for this week, here is the question. It says, my employer just announced they're implementing a fine system for incomplete tasks and infractions. If you don't complete a certain task, they will deduct it from your pay. Is that even legal?
So, John, why do employers do things without getting legal advice? Why? Why do the employers think, well, we know what we're allowed to do. Well, we're not going to bother speaking with a lawyer and getting legal advice. Nonsense, because if that employer would have gotten legal advice, they would have been told, they would have found out that you can't do that. You can't reduce the employee's pay. You can't unilaterally take money away from the employee. Even if the employee owes you money, you can't decide to deduct that unless the employee gives you written authorization. So this fine system is illegal. Don't do that, and that employee that's suffering that reduction, we can fix it. The Ministry of Labor can fix it. Your employer can't just deduct from your pay.
Is this something that a lawyer, or at least if an employer could do from the outset in a contract? It doesn't sound very nice, but could they do that and have it binding?
It would have to be very, very specific to say that, if you don't do X and Y, we can reduce the following from your pay, and by signing this, you give us authorization. And of course, that employee still has to get paid more than minimum wage, maybe, but it'll have to be very, very specific. In most cases, it's just not going to be possible. That pay is generally sacred. You have to get paid what you earned, what you worked for, and your employer can't just reduce from that or take away from that.
Again, reach out to Lior with any of these concerns, 1-855-821-5900, help at employmentlawyer.ca. The best part of the show, we put Lior in the hot seat. He loves this. It is Employment Rights Rapid Fire. It's coming up right now. Okay, Lior, here we go. You ready to strap in? Doesn't matter if you are. I'm still going to give it to you right now. First one, can employees be placed on an unpaid suspension? Unpaid.
So for non-unionized employees, in most cases, an unpaid suspension, not allowed. It could be a constructive dismissal. Your employer could put you on a paid suspension, maybe while they're investigating a few things, or even as a disciplinary measure, but unpaid suspension off-site for most non-union employees.
Rapid fire number 2, are employees allowed to extend maternity or parental leave? Wow.
So employees generally can extend it to the maximum allowable. So let's say, maybe 18 months you could be off as a mother for parental leave. You can't extend it beyond that. But if initially you were going to take 12 months, can you extend it to the full 18? Absolutely. But once you go past that 18, that employer is not legally required to keep your job. So yes, you can extend it to the maximum.
Quickly, are you allowed to split it with your spouse? If you also want to take half and they want to take half, you can do that?
Yes, there are defined rules in terms of how you split that with the spouse so that you both can be off either together or separately to extend the time with your newborn. So yes, you can do that.
Rapid fire number 3, are employees in the construction industry owed severance pay? Throwing an easy one towards you, pal.
That's easy because it's one word, and that is yes. 2 words. Absolutely yes. They're owed severance. Construction employees get severance calculated in the same way as everyone else. Misconception to think that you don't get severance. You absolutely do.
By the way, pocketemploymentlawyer.ca to do exactly what Lior said. Rapid fire number 4, can you be fired for cause due to poor performance?
Well, you can be fired for poor performance, but for it to be cause, you would have had something happen before, warnings, maybe other disciplinary measures. You would have had to do it several times. You almost would have to go out of your way to do a bad job, to lose your job for cause as a result of bad performance. And not doing well on a job or on a particular project does not mean that's a cause termination. It would still be a without cause termination, meaning you get your full severance.
It's a high threshold, right, as far as being able to pull the triggers, you say, in a termination for cause?
It is very difficult to terminate for cause. It's the death penalty. It's reserved for the worst offenders. So you would have had to do something very bad, so bad that it's just not possible to continue employing you. And in most cases, when an employer says that they're terminating for cause, they just don't have it, and that's a wrongful dismissal.
All right, last question for this week, Lior. Here we go. A big one. Can a harassment complaint be ignored?
Again, that's another easy one with 2 words, which is absolutely not. Your employer cannot ignore your harassment complaint. They have to investigate it, take it seriously, fix the issue. And even if it turns out that there's no harassment, or maybe your employer doesn't think that there was harassment to begin with, they still have to take it seriously. They cannot ignore it ever. So tell your employer if you're being harassed and put them on notice that they have to investigate.
And that is a wrap for another week, as they say in the business. Lior, thank you so much, and thank you for contributing as well through your questions through audio, your email questions to termination.com or email for that matter. I want you to know that you can reach out to Lior anytime now that we're through for this week. Phone number is always first, 1-855-821-5900, help at employmentlawyer.ca. And that website we've referenced so many times, where you can also find the severance calculator, free and anonymous, pocketemploymentlawyer.ca. Use it and then call Lior if you need to. Thank you so much for watching this week. We will catch you next time right here on the Employment Law Show.